I stand on my 2 feet. I'm in my proper person. I am sovereign. I am man. The flesh lives. The blood flows, along with the officer and sergeant who are already going to be getting sued. There's no need to add you as well.
Go ahead and have a seat, please. His rights at arraignment.
This courtroom hearing spirals into absolute chaos when a self-proclaimed sovereign citizen walks into court claiming the judge has no authority over him, the laws don't apply to him, and everyone involved is about to get sued. Within seconds, the defendant starts demanding the judge reveal her status, challenges the court's jurisdiction, and repeatedly insists he's appearing in his proper person. But the real shock comes when the judge calmly pushes forward, while the defendant refuses to cooperate with even the most basic courtroom procedures. What starts as a simple arraignment quickly turns into one of the most bizarre legal standoffs you'll ever see. And trust us, once the judge starts discussing evaluations and bail concerns, things only get more intense from there.
In this court, you are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply, not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last 2 are infractions. So,
ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case with prejudice.
That would be denied. So I am going to, at this time, review for probable cause.
Object. Again, I challenge the jurisdiction, and jurisdiction must be proven.
It's not going to happen today.
Jurisdiction must be proven.
To hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued, it would just add to that. And I don't think that you need to go that route.
While I review this incident report.
Right here is where the hearing completely shifts into full sovereign citizen territory. The defendant keeps repeating that the court has no jurisdiction and insists the judge must somehow prove her status before the case can continue. But legally, that's simply not how criminal courts operate. Jurisdiction is generally based on whether the alleged offense occurred within the court's authority, not on the judge personally answering philosophical questions about citizenship or status. Another important detail is the judge entering a not guilty plea on his behalf. A lot of people online misunderstand this process, but courts regularly do this when a defendant refuses to properly enter a plea themselves. It's actually designed to protect the defendant's rights while keeping the case moving forward. Meanwhile, every interruption and refusal to cooperate is making the court increasingly concerned about whether this defendant will follow future orders at all. Question for you watching: if someone truly believes the court has no authority over them, should they still be required to follow the court's rules?
That recently expired.
To question my competency because I'm establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
All right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating laws.
I was not driving. Again, I have rights.
You were behind.
My rights were violated. My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I
You.
am sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so I reserve all my rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also, indication that Mr. Schuster will not abide the court's orders to appear on his promise. Want to look at the Seattle Municipal case and see when he's next scheduled to appear.
Like you had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any.
This may be the most revealing moment in the entire hearing because the judge begins explaining exactly why she believes the defendant is a serious flight risk. And honestly, from the court's perspective, the concern makes sense. Throughout the hearing, the defendant repeatedly insists the court lacks authority over him, refuses to recognize the proceedings, and continues threatening lawsuits against the officers and even the judge herself. On top of that, the court discovers prior warrants and a deferred prosecution tied to another case involving DUI-related conditions. That combination becomes incredibly important because judges don't just look at the current charges, they also evaluate whether someone is likely to return to court and comply with future conditions. Even the defense attorney tries to argue these are nonviolent offenses and that the defendant should be released, but the defendant's own behavior in court may have ended up hurting his chances more than helping them. At this point, you can almost feel the judge realizing this hearing is going nowhere productive.
Ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I
don't see another date set until February 12th of 2025 in the Seattle case.
Seattle Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail. And any threats to sue me or to take any action against me, I can't be swayed by that. So
It's not a threat. It's just what it is. My rights have been violated, and if my rights are going to be furthermore violated.
$2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case, as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
When are you setting that court date, Miss?
Required by the Department of Licensing. You will be represented, because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented by anybody. I stand on my own 2 feet.
These are criminal charges that have significant consequences for you, so it's in your best interest to have counsel.
Again, I stand on my own 2 feet. I do not need to be represented by anybody. I present myself. Sui juris in propria persona.
If you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I do not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign. I am an American national, a non-U.S. citizen American national by way of America Samoa, like I had mentioned earlier. I reserve my rights, and I do not need to be represented by anybody.
All right. The time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
Next court date will be,
We want to try for next Wednesday or even the week after that.
well, next Wednesday's a holiday, so the 18th.
So for the record, you have not established status, you have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a U.S. citizen. A U.S. citizen cannot sit a bench.
Sign for your next court date.
You're asking me to sign something that you pleaded for me. Is that
Yes,
correct?
I'm giving you notice of the conditions that I have set, as well as bail.
You said
I'm
yes, you
noting that
pleaded
I
for
found
me?
Probable cause. If you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are
As this hearing finally comes to an end, the courtroom is left with a defendant who still refuses to recognize the judge's authority, still insists the court lacks jurisdiction, and still believes the legal process itself is violating his rights. But despite all the arguments, interruptions, and threats of lawsuits, the judge never backs away from procedure. Bail remains set at $2,000, legal counsel is still being strongly recommended, and the case continues moving forward toward future hearings. What makes this case especially fascinating is how it perfectly demonstrates the clash between sovereign citizen ideology and real courtroom procedure. Online, these arguments can sound convincing to some viewers, but inside actual courtrooms, judges almost always reject them immediately because the legal system simply does not recognize these theories as valid defenses. If you found this courtroom showdown as wild as we did, make sure to hit that like button, share your thoughts down in the comments, and don't forget to subscribe for more unbelievable courtroom drama, sovereign citizen fails, and real legal breakdowns every single week.